Speed.
Seth Rose, take one.
Companies are doing many things to mitigate the risks of litigation in the data security and data privacy areas. Among those things are following the principles provided for in the FTC's late 2010 privacy report. Some of those principles are privacy by design, transparency, and choice. Privacy by design is a concept where companies implement best practices as it pertains to privacy and data security through all facets of their organization. It involves making sure that you have best practices in place as it pertains to the collection of data, as well as to the retention and storage of data. As it pertains to transparency, many companies are streamlining their privacy policies to be much more concise and clear as to the consumer as to what is being collected, how it's being used, with whom it's being shared, and how it's being secured. Regarding choice, companies are moving towards providing consumers with various methods of opting in and opting out as it pertains to the collection and use of consumer data while they are surfing the web. This is typically referred to as do not track mechanisms, and it follows the suggestions of the FTC and various industry associations. Looking ahead to 2012, I think we can expect to see a privacy law implemented on the federal level. As it currently stands, there are several bills pending in both the House and the Senate, so it's likely that at least one of them will pass into law.
Speed.
Jim Taylor, take one.
I think the greatest vulnerability and challenge for companies going forward as it relates to the licensing or sale of data that they've collected is heightened regulatory scrutiny and certainly consumer scrutiny. It's an area of grave concern for consumers and for regulators. And I think the key for companies is really going to be to provide transparency to consumers, to educate and inform consumers as to how that data is being used, who it's going to, and what those parties that it's going to are going to use it for. The question often comes up as to who owns the data on a website. And it really depends on what data you're talking about and who owns the website and what's appearing on the website. Certainly a website publisher is going to take the position that any data that's collected on their website is going to be owned by them. However, if you're dealing with a publisher site and ads appear on that website, the advertiser is going to say anybody who views that ad and the data that you collect in connection with that advertisement is going to be owned by the advertiser. So it really depends on what data you're talking about and certainly what type of website you're dealing with, a publisher site versus an advertiser site, and so on. If I had to predict what was going to happen in 2012 as it relates to data security and privacy, I see a couple of things happening. I see more breaches. I see increased pressure on service providers to provide the necessary mechanisms to keep data secure. I think it's going to be the #1 discussion point in many agreements between advertisers and their vendors. And I think there is a distinct possibility that legislation is going to be introduced in 2012. Whether it's passed or not is another story, but I do think we're going to see more and more legislation both at the federal and the state level.